good afternoon, everybody. We'll be starting the talk soon. So kindly remember to put your devices on silent. Thank you for being early and waiting patiently. So while you're waiting, we would like to share a short video from the firm before we start. Please enjoy.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website. And we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Sorry, I just realized I was on mute. Allow me to introduce myself again. I'm Denise, Senior Associate with Matrimonial Assets. Welcome everybody. Please allow me to introduce our firm, walk you through a brief introduction of our firm. We were established in 1985 by Datuk Mawing Kwai, which is now a consultant with the firm. We are a medium-sized firm with 23 lawyers and 19 staffs, and are trusted by small, medium enterprises, family businesses, and individuals. We are a full-service law firm with 4 departments: corporate, dispute resolutions, employment, individuals, and families. We are also broken down into 5 practice groups, mainly ASEAN China Desk, our construction team, our foreign direct investment team, real estate, and sports and esports practice group. By way of background, we have been conducting MWKA online talks for quite a while now. This was actually, we have previously conducted our lunch talks traditionally since 2013, but due to the MCO, we have currently moved on to online talks to ensure everybody's safety. So our most recent online talk was on data privacy in Malaysia. Does it really exist? And then upcoming MWKA talk is on distribution of Muslim estates under the JKPTG, which will be held on the 27th of April 2021. Just follow our page and our Instagram page and our website. So there might be changes on the upcoming talk, but we'll keep you notified of any changes on our social media platform. So before we begin, let me just briefly introduce our speakers for today. Our first speaker is Ms. Wong Sue Ann, who is an associate with our Dispute Resolution, Employment, and Individuals and Family Department. She graduated from the University of London and is admitted to the Malaysian Bar in 2018. Her areas of practice include employment law, debt recovery, probate, administration of estate, construction law, and family law matters. Next, we have Mr. Jin Heng, who is also an associate in our dispute resolution team. He also graduated from the University of London and was admitted to the Malaysian Bar in 2020. His area of practice includes general litigation, family, citizenship, adoption, probate, and administration of estates, debt recovery, and land disputes. So without further ado, before I pass the floor to our speakers, we have actually a mechanism for participants to ask questions. So this is called Slido. It's a party website. You can scan this QR code to access the Q&A polling platform and post the questions there. You can also vote for any similar questions that you like, and the most liked and popular questions will be discussed and answered by the speakers at the end of the session or during the Q&A session at the end. So you can scan this QR code, or you can visit www.sli.do and enter the number #333420. That is 333420. I'll be also posting a link to the Slido website later on in the chat, so you can keep an eye on that. Without further ado, these are our talking points for today, and I'll pass the floor to our first speaker, Mr. Jin Heng.
Good afternoon, everyone. I'll be your first speaker today. My name is Jin Heng. So as you can see from the slides, we will be sharing on 3 talk points today. The first one will be an overview of divorce orders, and then after that, we will proceed to the second point, variation of maintenance orders. After that, my colleague Sue Ann will proceed with the variation of custody orders. To begin with, in Malaysia, the primary legislation for non-Muslim marriages and divorces is the Law Reform Marriage and Divorce Act 1976. So in Malaysia, non-Muslims, their marriage and divorce are governed differently from Muslims. Muslims, their marriage and divorce are governed by Sharia law. So any disputes will be directed to the Sharia courts. So for the purpose of today's talk, the variation to the divorce orders will be in relation to non-Muslim divorces. Matrimonial matters in relation to non-Muslims in Malaysia which are governed by the LRA here will be heard in the civil courts. So any divorce proceedings will be heard in the High Court. There are 2 types of divorce proceedings. There is a joint petition and also a contested or single petition. So for a joint petition, this is usually where both spouses, they agree to divorce and they have consented to the terms of their divorce. So in such a situation, both spouses will sign a joint petition and make an application to court to divorce. However, if both parties do not want to divorce, so for example, the wife wants to divorce but the husband does not wish to divorce, wife can initiate a contested or single petition to court. So aside from that, this also happens where both spouses do not agree to the terms of a divorce, and hence in such a situation, it will be a single petition divorce. In both situations, if it either a joint or a contested petition, once the petition is heard in the court will grant a divorce order. And in that divorce order, it will contain all the terms of the divorce. So example of the terms will include distribution of the matrimonial asset, custody of children, who will get the custody of the children, and how much maintenance is paid husband to the wife or the other way around. So the divorce order given by the court will contain all the terms of the divorce. And usually the divorce order is final, but even though it is final, it is subject to variation in limited circumstances. So if any changes arise, the parties may make an application to court to subsequently vary the divorce order. However, the circumstances in which the court can vary the terms is very limited. After a divorce order is granted, the court can only vary the terms in the divorce order if it's in relation to the maintenance paid to the wife and the children, the custody of the children, and also access to the children. We will now move on to our second talk point of the day, the variation of maintenance orders. So what is maintenance? There are 2 types of maintenance. The first one is spousal maintenance, and the second one is child maintenance. So for the purposes of spousal maintenance, we will refer to Section 77 of the Law Reform Act. Under this act, the court is empowered to order a man to pay maintenance to his wife. But we should take note that under this act, the provision does not provide for the wife to pay maintenance to the husband. However, the court can still order the wife to pay maintenance to the wife, but only in very, very limited circumstances. So under Section 77, the court may order maintenance to be paid to the wife during the course of any matrimonial proceedings or after the divorce is granted. So the court may order the husband to pay a certain amount of maintenance to the wife after the divorce. So spousal maintenance, which we are continuing on that. So usually the divorce order will contain the terms that the husband will have to pay maintenance to the wife. And there's of course, unless the wife agrees that maintenance is not required, then it won't be in the divorce terms. So maintenance payments, they can be made by 2 ways. One is a one-off lump sum after the divorce, or it can be made periodically. So for example, the terms can include maintenance payments such as the husband to pay the wife a certain amount every month. However, for spousal maintenance, the order will expire if 4 situations arise. So as you can see on the screen here, the first situation, the death of the husband or the wife. If it is an unsecured maintenance, and unsecured maintenance is type of maintenance where it is directly paid by the husband to the wife. So if the terms of the divorce order says that the husband has to pay the wife, for example, 1,000 ringgit per month, that is unsecured maintenance because it's paid directly from the husband to the wife. So in such a situation, if either the husband or the wife dies, the maintenance will cease to exist. So for example, if the husband is to pay the wife 1,000 ringgit every month, if either of them dies, the maintenance will stop. And the second situation would be secured maintenance. So a secured maintenance is a situation where instead of the husband directly paying to the wife, the terms of the divorce order would provide for a situation where the husband is to vest a property in a trust and the maintenance will be paid by the trustee to the wife every month. So in such a situation, if this is a secured maintenance, and if the husband dies, the maintenance will still continue to be paid because it is paid by the trustee, not the husband himself. The maintenance will only cease to exist only if the wife, which is the person which the terms is in favor of, dies. So this is for secured maintenance. And of course, if the spouse in question remarries, the maintenance will cease to exist. So for example, if the husband and wife divorce, and after their divorce, the divorce order provides for maintenance to be paid to the wife every month. The moment the wife remarries, the husband is not obliged to pay maintenance anymore because the order of maintenance is expired. Another situation would be where the spouse lives in adultery. So this would not happen if they are divorced, but maintenance is not paid only if the wife and husband divorce. So for example, if the court has ordered maintenance to the wife, even though they are not divorced yet, or probably because they are still pending divorce proceedings, if the wife is found to be living in adultery, any maintenance order would expire and cease to exist. Okay, we will now move to maintenance for children. Under Section 92 of the Law Reform Act, it is stated that it is a duty of a parent to maintain the child, even though it is not in his custody. So, for example, if the custody of the child is given to the mother, the father, although not having the custody of the child, is still obliged and it has a duty to maintain the child. Under Section 93, it states that the court has a power to order a man to pay maintenance for the child if he falls in these 4 situations. First one would be if father refused or neglect the child. Secondly, he has deserted the wife and the child. Number 3 is during the proceedings of matrimonial proceedings. And of course, the final one would be after making an order placing the child in either spouse's custody. So child maintenance. So child maintenance will usually be paid to the parent having custody and care of the child. So for example, if the custody is given to the mother, the maintenance will usually be given by the father to the mother on behalf of the child. So it won't be paid directly to the child because the child is still definitely underage. So in addition to maintenance payments, the parties can actually also agree among themselves to apportion maintenance for the child's education and also other fees such as medical expenses and also insurance premiums. So for maintenance order for children, it will usually expire when the child reaches the age of 18. However, in light of the recent amendments to the Law Reform Act, which was in force since December 2018, the maintenance will not automatically expire after the child reaches 18. So for example, if the child is pursuing higher education, maintenance order will not expire until and when the child ends his higher education. So we will now move into variation of maintenance. So the variation of maintenance is provided by Section 83 and 96 of the Law Reform Act. Under these 2 sections, the court has the power to vary or rescind an order of maintenance at any time if the court is satisfied that the 3 situations shown on the screen applies. So if it's a misrepresentation, mistake of fact, or there is a material change, the court will vary or rescind an order. So what is vary and rescind based on the sections? So vary has been given a wide meaning. So it is not confined to only increasing or decreasing the amount of maintenance that has to be paid. So the court can also suspend the payment or revive it if it has been suspended previously. And rescind itself is putting an end to the maintenance. So the court has power to do both of this, to increase, decrease, suspend the maintenance, or to put an end altogether to the maintenance based on the divorce orders. We will now move on to the first ground for variation of maintenance. So the term misrepresentation itself is actually not defined in the Law Reform Act. So we may refer to the Contracts Act to define what is misrepresentation. As you can see here, it is a positive assertion which is untrue. So something that is untrue and it is in breach of a duty and will give advantage to the person doing it. And finally, it will cause the person in an agreement to make a mistake. So an example of misrepresentation would be one spouse concealing the wealth or income during the divorce. As you can see from this case in Sim Tong Realty against Tay Kim Da, the court has broken down the definition of misrepresentation into three elements. So the first element is that the representation made must be an unambiguous false statement of fact. So the first element would be that it must be false. And secondly, it must be addressed to the person that was misled by that representation. And finally, there must be material inducement. So if not for the representation, the other party will not be induced. So if it can be shown that one of the parties to a divorce was misrepresented into agreeing to the terms of divorce, the other party may apply to court to make a variation application. So an example of this would be, for example, where a husband and wife filed a joint petition for divorce, which both of them agreed the terms already. So in this joint petition, the wife agrees to receive 1,000 from her husband because at the point in time when they prepared the joint petition, the husband expressly told the wife he's only making about 3,000 or 4,000, so he can only afford 1,000. So despite not enough to cover the wife's costs, she agrees based on the husband's representation that he can only afford 1,000. So after the divorce order is granted, if the wife discovers that the husband actually was concealing and did not actually disclose how much he made during the joint petition, she can apply to the High Court to vary. So for example, if she discovers that he actually makes about 10,000 and actually 1,000 is not much, she can apply to the High Court to vary the maintenance because when they went for the hearing of the joint petition, she was misled. She was under the representation that the husband only made 3,000 or 4,000 and he can only pay that much for maintenance. So in such a situation, the wife can definitely apply to the High Court to vary the maintenance order so that the maintenance will be increased from the 1,000 which she was initially misled. So the second ground is mistake of fact. And similarly to misrepresentation, mistake of fact is actually not defined in the Law Reform Act, but we can refer to Contracts Act, Law of Contract, which states that a mistake of fact is ignorance, forgetfulness to the material terms to the contract, which actually does not exist. So an example of this would be in the case of Lisa Gertrude Strong here. So in this case, in 1995, the wife obtained maintenance order against husband to pay monthly maintenance. But 10 years later, the husband applied to rescind the order of maintenance and to reduce the maintenance paid to the child. So this case went on appeal, and in the Court of Appeal, the court found that there was a mistake of fact because the lower courts granted the maintenance not knowing the husband did not have the ability to pay the maintenance. So as you can see here, since 1995, the husband was actually in prison and he definitely did not have the means to pay maintenance as he was only gainfully employed almost 10 years later in 2004. So based on this situation, the Court of Appeal held that when the maintenance order was granted in 1995, there was a mistake of fact. So in such a situation, the Court of Appeal decided to vary the maintenance order. So instead of starting to pay from 1995, the court amended the maintenance order to start from 2004 onwards when he started to work, and also reduced the maintenance a bit from what was initially granted. Now we move on to the final ground, which is material change in circumstances. This is one of the most common grounds used in applications for the variation of maintenance orders. But the key thing here is that there must be a material change. It cannot just be a normal or just an essential change. So the proper approach of this would be to start from the original maintenance order and see what has changed financially or otherwise. So we will give an example of that, which is unemployment or retirement, accident, deteriorating health condition, and also changes to the financial position. So an example of a material change can be seen in this case. So in this case, Anate, the wife actually obtained a maintenance order in 1986 against the husband. So the husband has to pay monthly maintenance of 500 to the wife. But almost 10 years down the road, the husband filed an application to rescind, which is to cancel off the maintenance order because of the following reasons. He's 60 years old, which means that he's probably retired at that point in time because he's 1984. And he was in poor health and he no longer had a permanent job. And even though he was remarried, he was actually relying on his new wife. So in these circumstances, the court held that there was definitely a material change and the court ended up rescinding the order because he definitely is unable to pay for the maintenance. So another situation which is different would be Karen Yong. In this case, the court held that there was no material change. So roughly what happened here was that the wife actually obtained a maintenance order which required the husband to pay monthly maintenance to the son, and it will be increased to 1,200 ringgit until the child turns 21. But 5 years later, she applied to vary the maintenance to increase the fees because she said that there was a material change in circumstance as the child was a teenager and needs to go to a better school, which is more expensive due to his dyslexic condition. So for this case, the court held that there was no material change because, firstly, the wife did not prove that the child was dyslexic, and she failed to justify the decision to enroll the son to an expensive international school, which actually both parties cannot afford. And at the end of the day, this financial difficulty created by the wife is actually inflicted by herself. So the court ultimately held that there must be a differentiation between a want and a need. So for this situation, the court dismissed the wife's variation application and did not allow the maintenance order to be increased. Okay, now we come to matrimonial assets. So under Section 76 of the Law Reform Act, the court has the power to order the division of properties or assets when they grant an order for divorce. So at the point in time when the parties are divorcing, the court can portion the division of the assets. So for example, the wife gets 50%, the husband gets 50%. But it is important to take note that matrimonial assets cannot actually be varied in the court. As you can see from this case, Liu Chong-yi, the Law Reform Act does not provide for variation of division of matrimonial properties. So if the divorce order provides for division 50-50, parties cannot subsequently, after the order is granted, go to court to vary the division percentage again, because it is actually not provided for in the Law Reform Act. Okay, I have now ended my part. I shall now pass on the talk to Sue Ann. Sue Ann?
Now we'll start with varying custody orders. Okay, so actually, who can obtain a custody of a child? When we're talking about a child, under Section 87, it concerns a child under the age of 18, and who the court can decide who to make the custody order, who to give custody of the child. So it could be the father or the mother or joint custody. But what happens if the parents are not suitable to have custody of the child? Then under Section 88, it also empowers the court to place the child under the custody of some other relative, an association, or any other suitable person. But Section 88 goes on further to say what kind of consideration the court will take into account when granting the custody. So it could be welfare of the child, the wishes of the parents, the wishes of the child. Now, Section 88 specifically also has a rebuttable presumption, wherein if the child is below the age of 7, it should go to the mother. But again, this is rebuttable, meaning if, let's say, the father wants custody of the child, the father can bring evidence to show that the mom is an unfit parent, then that would rebut this particular presumption. But as it stands, by law, this is the presumption that usually judges will take into account. Next, when the judge gives like a custody order, they can also impose certain conditions to it as the court thinks fit. So what kind of conditions? Like, for example, where should the child reside? What kind of right of access to give that particular parent? Or, for example, there's a prohibition from that particular parent from taking the child out of Malaysia. So those are certain conditions that the court can impose where they see fit, and depending on what the parties pray for. So, can you have custody of your child forever? Well, under Section 95 of the LRA, the order for custody ceases when the child attains the age of 18 or completion of further or higher education, whichever is later. But what if that child has a physical or mental disability? Then the custody order only ends on when that disability ceases. So earlier my colleague has already introduced to you Section 96, of the LIA, which concerns both custody and maintenance of the child, wherein you can vary an order if there is mistake of fact, or where there's a material change in the circumstance. Then you might be wondering, what about the welfare of the child under Section 96? Well, court has decided, especially in this particular case, it says that in my view, the fact that an earlier order in respect of custody can be read means that the welfare of the child being the paramount considered is an integral part of Section 96. So just because it's not stated in Section 96 doesn't mean that the welfare of the child is not taken into account. We also have Section 97, which can be used to vary an order as well. But this concerns when, for example, where parties enter into an agreement before you obtain the decree nisi, wherein here it specifically states that if you want to apply for a variation, it must be reasonable and it must have the welfare of the child taken into account. Earlier, when I introduced Section 96 to you, there's a few grounds, remember, misrep, mistake of law, and material change in circumstances. So for this talk, I will focus mainly on material change in the circumstances because that is the most common ground you will see when people apply to vary the custody order. In this case, YCC, two grounds were actually raised. One was for misrep and one was for material change in the circumstances. Now, why was there a misrep? This is a case law example for you. Husband is challenging the paternity of the child, saying that the wife has misrepresented him to say that that child is his child. Whereas as to material change in circumstances, he is arguing to say that the divorce order should be varied because of his financial circumstances. And the wife has someone else to take care of her now. So those were the grounds that the husband raised. So in this case, the court said that if you are to raise that, if you are to say that there's a material change of circumstances, you will have to prove, you bear the burden of proving that on a basis of probability that there is a material change of circumstances. However, if you fail to do so, it doesn't mean that the burden shifts to the other spouse to disprove the allegation that there are material change of circumstances. And for this case, eventually the judge decided that, look, that there wasn't any material change in circumstances at all. You failed to prove that that your financials has changed. You only showed us one bank account. You could have other bank accounts as well. That it wasn't sufficient. It wasn't enough to show to the court that there were material changes of that husband's circumstances. This is how judges have interpreted what amounts to material circumstances, where the material circumstances means that there's an existence of an essential or critical factual change. And of course, it depends on the fact and circumstances of each case, but mostly you must show to the court that it's not just a simple change, it is a material change. What are case law examples of what amounts to a material change in circumstances? In this case of legacy, it involves a breach of the decree nisi. So what happened was the wife had ignored the terms of the decree nisi and absconded with the child out of Malaysia. So she took the child, she took the child and left Malaysia and then didn't give the husband access to the child at all. So the husband applied to the court to vary the custody order because of the change in circumstances. The court held that the husband was entitled to vary the custody order on the fact it was for the welfare of the child that the husband be granted sole custody, since the wife had proven herself unreliable and untrustworthy with regards to her obligation under the decree nisi. So in this case, the husband successfully proven that due to the wife's constant breach of the decree nisi, there were material change and he should be granted sole custody of the child. Why? Because in this case, he could show that the wife was currently living with was currently cohabiting with another partner, and then the wife just uprooted the child and then brought the child to somewhere that she was not familiar with. So the judge considered those as being unreasonable and detrimental to the child's welfare. Next, so in this case of Jane Dripping, the husband alleged that there was a change in circumstances warranting a variation of the decree nisi because his child's education was in peril. Why? Because she was not doing well in her examinations, and that the child is allegedly still fearful of the wife. Now, I have to explain to you this. When the case was filed, the daughter was in Form 4. So facts have shown that she failed 2 subjects, and the husband is saying that the daughter's education is now in peril. Fun fact, she failed 2 papers, which was maths and biology, but she passed the rest of the papers, and the husband now is saying that, look, my daughter failed her papers, so it shows that the wife is not taking care of her properly. So I should be granted custody of my daughter. Court held that the fact that the daughter had failed in 2 of her Form 4 papers is insufficient in circumstances of the case to constitute a substantial or material change in circumstances. And then, so just because there was the daughter failed, it wasn't enough to show that the daughter's education was in peril, because I believe all of us will understand that MS is not the easiest subject, especially when you've just started Form 4. No, the court said that the husband can actually assist using multimedia like computers and whatnot to assist the daughters in study without having the daughter move and to stay with him. And furthermore, the judge also said that there was no evidence that the child was involved in any unhealthy activity or there was any disciplinary issue. And the pressure that she faced, the fear that she faced, was because the mom is the normal pressure that you face from your parents who were concerned about your studies. So it didn't amount to any material change in circumstances. Okay, next. This is a pretty common ground as well. For a divorce where one parent remarries. So in the case of 2TT, the wife was initially granted sole custody, care and control of the children. She could continue living in the matrimonial home with the children, and that the matrimonial home will be transferred to the children's name once they attain the age of 18. Reasonable access was to be granted to the husband. Later, the husband applied to vary this particular order and so that the custody be granted to him instead. One of his reasons was because that the wife has now remarried and already has a child out of her second marriage, but she continues to stay in the matrimonial home with the children, with her new husband, and with the child out of her new marriage. So basically, the husband is alleging that now the wife is not capable of providing the same care and attention to the children because she already has a second marriage and already has another kid. And that by allowing her new husband and her new child to live in the same matrimonial home is disregarding the welfare of the children. He also argued that he was in a better position to have custody of the child because he has a stable income and that he could ask his parents for help to take care of the children's needs. So what happened in this case was, after considering the facts of the case and whatnot, the judge held that the husband didn't prove that the wife's new marriage amounted to a material change in circumstances. And the judge found that children are actually attached to their new stepfather who cares for them as his own children. So the children are now living in a family environment now, and that the present arrangement is working well. So the judge didn't wish to disturb the existing custody so that it will not affect the welfare of the children. This case concerns a child which was sexually molested. So what happened was, in this case, initially the parents were granted equal custody of the child, whereby the child was to live with her father and his parents continuously for 3 weeks, and then with the mother for the same period of time. Later, it was found out that the husband's father, so it is the child's grandfather, was actually sexually molesting the child, and they actually filed a police report for it. After they filed a police report, the wife applied to vary the custody order and is now seeking for sole custody of the child. In this case, judge held that there is no doubt that more care should be given when dealing with such issues, especially when the child is a victim of sexual abuse, would be in dire need of this court's protection. The judge found that if he didn't vary this particular this custody order granted in the decree nisi, there is a real risk that the child might be harmed either physically, emotionally, or sexually. Because in this case, the child was the primary witness to the act that the grandfather did to her. The judge allowed the variation because this amounted to a material change in circumstances. Next is the case of Ananda Dharmalingam. In this case, one of the grounds that were raised is the mental state of the parent. In this case, in particular, it was the mother. 2003, the custody of the children were initially granted to the husband, and an injunction was granted against the wife from taking the children away from the husband and away from the jurisdiction of the court. Later, the wife applied to vary order in 2013, and the judge allowed it. This High Court judge allowed her to have custody of the child, allowed her to bring the children to stay with her in Australia, and a complete opposite, no access to were granted to the husband until a child psychiatrist has certified that the children are ready and prepared to meet the husband. The husband then applied to the Court of Appeal, appealing against this order by the High Court. The Court of Appeal dismissed the application on the grounds that there were two doctors' report stating that the wife did not suffer from depression or any mental illness, and that she is a fit mother. And it was for this basis that the High Court in 2004 granted the custody order to the wife. The next one, it says that Dr. Chin confirms the finding of the two doctors. This Dr. Chin was the original doctor who in 2003 prepared a report which stated that the wife was suffering from mental illness, and that was the basis that the custody was initially granted to the husband. So because even Dr. Chin has confirmed the findings of the two doctors, Court of Appeal said that, look, the High Court was right to grant the custody order to the wife now. Another point that the court considered was that the children wanted to be with their mother. So in this case, there were two kids. They were very adamant that they should stay with their mom. In fact, one of the doctors in their report noted that the relationship with the dad was so bad to the point where one of the child said that he would want to kill the dad. So after taking all this into account, the judge felt that the custody should be granted to the mother instead. So the judge in the Court of Appeals said this: the husband should accept the situation where that the children could not be compelled to see their father under the present circumstances. It was certainly not the intention of the learned judge to have the husband, as the father of the children, debarred from access in the sense that he was unsuitable. But the circumstances as it stands, the two children did not want to see their father, and hence it was better for the mother to have custody of the children. And that will be the end of my talk right now. But I would like to say that if, let's say, anyone out here would like to vary an order, these are the circumstances that you would have to consider, because divorce is not easy for both the children and the parents as well. And lastly, we offer a new service wherein you can get an online code for if, let's say, you like to apply for joint petition. And I believe my colleague will post the link to this to the webpage, so you can see that we offer online codes for 4 types of divorce, specifically divorce with children, divorce with division of assets, and divorce with children and division of assets. With that, I will pass the floor to Miss Denise.
Okay, thank you, Sue Ann, for your insights on the topic. What we can take away today is that maintenance and custody orders are not set in stone. They can be varied and in limited circumstances. So now we would like to take questions from audience or participants. If you allow me to share our screen. Okay, so we will be taking questions by Slido. If any of you have any questions, you can actually scan this barcode on the left of my screen, the screen that I'm sharing. And we already have 3 questions here, so we'll go through them shortly. Okay, Now, the first question is from Mike. And the question goes, if there was no maintenance order granted for the husband to pay maintenance to the wife, can the wife apply for a maintenance order years after the divorce? I believe this question would be for Chu. Chu, could you take this question, please?
Yes, okay. So this question is asking about whether even after a divorce, can the wife still apply for a maintenance order? Okay, as I've discussed just now, under Section 77, there are a few situations where the court can still grant maintenance from the man to the wife. So this will also include situations where it is after the grant of a decree of divorce. So this means that even if it's before the divorce, during the divorce proceedings, and after the divorce proceedings, the court can actually still grant a maintenance order to the wife. So for this question, in such a situation, the wife, if they feel there's a need, they can go to the court and apply for a maintenance order a few years after the divorce. That's the answer to the question.
Okay, thank you very much, Chu. So we are done with this question. The second question, what action can be taken if the spousal does not pay the maintenance after the divorce order? So I believe this question can, Sue Ann, can you answer this question, please?
Yes. Okay. So what action can be taken if the spouse does not pay maintenance after the divorce order? One of the most effective methods is actually to commence a committal proceeding, wherein if you're applying to court to say that, look, this person didn't comply with the order, certain action has to be taken. And a committal proceeding, there are two outcomes. If, let's say, that person still chooses to it can be proven that that person didn't comply with the order. One is a fine, and the second is to actually commit the person to prison. So that person can go to jail for that person's failure to comply with the divorce order.
Thank you, Sue Ann. Just a reminder to all our participants here, this Q&A session and this entire legal webinar does not constitute legal advice. So if you require specific legal advice to your circumstances and your case, you are free to contact us for a 30-minute free consultation, and we arrange for a separate meeting later after the meeting to address your case. But so the Q&A session here is basically general advice. Okay, so now let's move on to the next question. This is from an anonymous participant. If the decree or divorce order of maintenance is from Dubai, would Malaysia court recognize it and reinforce it? I believe this is your question, Sue Ann. Could you answer this?
Me. Yeah, I'll answer this question, yes. Okay, so for this question, I'm not sure whether this is in relation to a marriage which is between non-Muslims or Muslims, because as mentioned earlier, the Law Reform Act regulates marriages of non-Muslims. So for this situation, it will depend whether the divorce order is for a Muslim marriage. If it is for a Muslim marriage, it will be under the purview of the Sharia law. So for this one, it will ultimately depend on type of marriage, and also it will depend on what kind of laws were applied for the divorce order in Dubai, because whether it is a monogamous marriage or not. Because under Islam, they allow for monogamous marriages. That's my answer to the question.
Okay, thank you, Chu. So are there any other questions from the participants? If not, that's the end of our Q&A session already. Maybe I'll just give you guys another few minutes to put in your questions if you have any. In the meantime, I would like to introduce all of you, our new up-and-coming talk. So our next talk will be on the 5th of May 2021. It's on the topic of ABCs of land acquisition. And the speakers for this upcoming talk will be our Mr. Eric Toh and Ms. Vivian Phang. Now, if I could just come back, just check in with Slido again. Yep, there are no other additional questions. So thank you, everybody. Next, you could also follow us on our social media platforms to know more about our up-and-coming talks. So we have YouTube, Twitter. We are on YouTube, Twitter, Instagram, LinkedIn, and also Facebook. Again, if I can just share our next upcoming talk. Yep, this is the one. It's on 5th of May 2021 on ABCs of the land acquisition. This will be compulsory land acquisition in Malaysia, normally for development or public works. And our speakers for that talk would be Eric To and Miss Vivian Phang. Okay, that brings us to the end of our session today. Thank you, everybody. Thank you for spending the afternoon with us. I hope you've learned a lot about varying maintenance and divorce orders. And if you have any other questions, you can always schedule a free consultation session with us. And we'll see you in our next talk. Thank you.
Thank you. Thank you for joining us. Bye-bye.